right? You each have 10 minutes aside that would include any opening and closing statements should you all choose to make one, as well as any examination. All right, sir, would you like to make an opening statement at this time?
I believe I would like to try, Your Honor.
Okay. So just because you all are representing yourself, I just want to state that you all are held to the same standard as an attorney. So when an objection is made, you all will just stop speaking and wait for me to rule on the objection. Then, depending on how I rule, will let you know whether you need to ask another question or you need to continue with that question that you were asking. And you're just telling me what the evidence is going to show in your opening statement. Okay. All right.
Okay,
So
Your Honor.
go ahead.
Your Honor, I would like to tell this court that there is a Pennsylvania court order that was made as a legal custody order for the children in this suit in 2015. And then following that, there was actually a second custody agreement that was signed into another custody order in 2017, which at the moment this court does not have. But it is part of State's Exhibit 4, which references a agreement as part of the divorce decree. That agreement is not part of that exhibit. However, it does exist, and it is actually what I believe is now the current standing order that I obtained over this past weekend on April 24th of 2026, actually, so Friday before the weekend. I filed it into this file record and gave it to Ms. Cosby and the Attorney General's office over the weekend, as soon as I was able to become aware of it. And so to my understanding now, the actual most recent custody order is in 2017, not 2015. However, I did not have that in my records until this past weekend.
Okay.
However, I am indeed the one who is bringing subject matter jurisdiction, as a default order was created, and I am here attempting to challenge that default order under the fact that there was already a prior custody order with 50-50 possession, and I have had 50-50 possession of my children for the large majority of the past 10 years, Your Honor.
Okay, thank you. Can the state and Ms. Cosby confirm that there was an order tendered to you all from the Pennsylvania court that is dated 2017?
Ms. Bailey, if I may?
Yes.
There was, whenever we divorced in 2017, there was absolutely no custody order gone through by the court. At one point, due to the high conflict nature, my attorney at the time recommended that I wrote up an informal order in order to get permission to move counties. In Pennsylvania, I had to let him know if I wanted to move and get him to agree. We wrote up an informal order, which signed that said I was going to move counties. He signed it. It was filed into the court. However, it was not ever brought before a judge, reviewed by the judge, or signed by the judge. I have confirmed with the Prothonotari's office and my prior attorney that just because it was scanned in does not make it a legally binding court order. And they both have attested to that it is not a court order. It was an informal agreement meant to serve notice that I was going to move counties.
Sorry, I'm going to need to know the exact date that was sent, because I'm not seeing that from any other. The last correspondence that looks like I have is from the 24th, which is the Friday.
Sir, is that the day that you sent the order you're referring to?
I sent it to Miss Alina Franklin over the weekend, Your Honor.
Let me double check. It was sent directly to her. She hasn't uploaded the file.
Well, first I sent it just the agreement on Friday. Then I sent her the entire divorce docket, which shows that each piece of paper was filed one right after the other. And then 3 days later, the divorce decree was signed, which specifically references Annex Settlement Agreement. And again, if you look at the 4 pieces of paper, they're fired 1035, 1036, 1037, 1038. It is 1035, the custody custody agreement 1036, the affidavit for mother for divorce. Mine is the next minute, and then the third one is the praesive to send these receipts from her attorney. That all was sent all together, all four, to the courts, and then 3 days later, the divorce decree was finalized.
All right, guys, this case wastes no time pulling you into a procedural battlefield where both sides are representing themselves under strict courtroom rules. The father steps in with confidence, laying out a complex history of custody orders from 2015 and 2017, immediately signaling that this isn't a simple dispute. He frames himself as a long-standing 50-50 parent, but also admits key documents were only recently found and filed. That alone raises questions about credibility and preparation. You can already feel the tension building because everything hinges on paperwork, and whether it even exists in a legally valid form.
I'm still double checking with Ms. Franklin, Your Honor.
Okay. Because I do believe that would be something that the court would need to entertain if you're saying so. And I'm not familiar with Pennsylvania law or anything like that. Was this a modification to the decree?
Your Honor, what happened was, as Ms. Cosby stated, we briefly remarried and then divorced a second time. Ms. Cosby incorrectly states how it happened, but we divorced, we remarried, and in the second marriage, we signed a written agreement, which was submitted right before our divorce.
And is that the agreement that we have, or is that something different?
It is not the 2015 agreement. It is something different, which again, I have attempted to file into this court, and I'm requesting that you admit it to at least look at it, and you can determine for yourself whether or not it is a legal court order.
When did you file it? On Friday?
Unfortunately, I filed it on the weekend, Your Honor, so it was on Saturday, I believe. It is still pending in the court records. The service notifications were sent out to Ms. Cosby. However, I do not believe that the court's records have officially accepted it as of this moment.
But I don't see it. The last thing I see is mother's motion to confirm jurisdiction under the UCCJEA that was filed, I think, like Wednesday of last week.
Yes, Your Honor. I do not believe it is actually officially gone through all the way yet.
Okay. State.
Yes, Your Honor. So confirmed that we did receive an email. It was a custody agreement signed by only mother and father in October 2017. But there was no judge's signature. The issue with this is that there are 3 children before the court, and the official orders that are signed by a judge only include the 2 eldest children, not the youngest. So there's the added complication of unless there's a judge signed order from Pennsylvania regarding the 3rd child, the subject matter jurisdiction is not retained in Pennsylvania. However, the normal way we do this, Your Honor, so that the state is, or so that the court's aware, is that we would have registered and tried to modify the order concerning all of the children had there been support provisions. But if the court is going to request that the Pennsylvania orders be, registered with the court before any modification, which a court could potentially do, that regarding the custody, and I don't believe that the state would be involved in that. Unless we were to do this the typical way, which we refer to as add baby cases, where we will set everything up for the youngest child, but not regarding the eldest that are already established. So that would be up to the parties to register and modify that order as they wish. The state's position is that the child support, however, could be addressed by the court today.
Okay, so here's the issue. Because it doesn't sound, has that Pennsylvania order been registered in Texas yet?
No, Your Honor. No Pennsylvania order has been registered.
Okay, that's the first issue. The second issue is that the UCCJEA requires a conference between the Texas court and the Pennsylvania court to determine if the Pennsylvania court, who right now, as of what the court is understanding, still has continuing exclusive jurisdiction over the custody and the conservatorship portion. They need to conference to see if Pennsylvania is going to retain jurisdiction or is going to relinquish to Texas, and it doesn't sound like that has happened yet. So I would need to make sure that that portion happens first, because I don't want to infringe on another court's order without knowing if they're going to relinquish. So I think the best thing to do is to abate this hearing for now and schedule a conference between the two courts to see if they're going to retain or relinquish. Because if they relinquish, that's a no-brainer. Texas will then have jurisdiction. If they retain it, Texas does not have jurisdiction.
Buckle up, guys, because this is where the story sharply pivots. The mother comes in and dismantles the father's claim, arguing that the so-called 2017 agreement was never approved by a judge, making it legally meaningless. That's a direct hit to the foundation of his entire argument. Meanwhile, the father scrambles to explain filing timelines and missing records, creating a sense of confusion that even the judge struggles to untangle. This moment is critical because it exposes a classic courtroom issue: what people believe is legal versus what actually holds up in court.
So I think that needs to happen first.
Your Honor, may I ask a question?
Yes.
So when I was reviewing the law, and again, in conversations I'd had with the Attorney General's office regarding this, it was brought up that Texas Family Code 152-203 says that number one, if the other state determines that it no longer has exclusive jurisdiction, that Texas be able to modify it. It says, or if the court of Texas determines that the child's parents, and any person acting as a parent do not reside in the other state, Pennsylvania would no longer have continuing jurisdiction. And so the thing I would like to bring up is that it is not even contested that both parents and the children live in Texas and have for 5 years. And so I would ask that the court just confirm that we do meet qualification 2, although the typical proceedings does say, number 1, to transfer it. We do meet the legal requirement in number 2 that the court of Texas can find that the child and the child's parents no longer reside in that state.
Yeah, and you see, the order isn't even registered here. So your order has to be registered here too. And unfortunately, this didn't happen first. This part usually happens first, so you all don't get to me, right? But that's not what happened. So you all are here now, and the way that I believe the cleanest way to do it is to have the two courts conference. Yeah, I think that's the best way to do it.
Your Honor, so what do we do about my third child who does not have a judge-signed, legally binding court order in the meantime?
Well, and see, that's the part I can't tell you, because that'll be giving you legal advice. And honestly, I don't know how that even happened. I just will just tell you straight out. But everything is somewhat contingent on what happens with the conference. You know, as I said, if Texas has jurisdiction, then we will be able to do something to make sure that that third child is included in the order, because they can't have an order that just pertains to them only. They have the same parents. So we would have to add the child anyway, but we can't put the cart before the horse. So we're going to abate this. So, yeah.
Your Honor, may I ask a question?
Yes.
I apologize. I am not a lawyer. What does abate mean?
So stop.
Specifically as it pertains to this.
Just stop this. Like, I'm not going to make a ruling.
So what would that mean as far as the default order? I apologize, Your Honor. I did not mean to interrupt you.
No, as of right now, the default order is just sitting still. As of right now, but that's why I said this should have taken place before an order was done. Because when an order comes first, before jurisdiction is determined, you run into these types of situations. You get placed in a court order. People have certain rights and duties that they're bound by, unfortunately, right? But jurisdiction is at issue. So for whatever reason this didn't happen, I'm just trying to remedy that now. So I'm working backwards. So as of right now, that the order, I have to abate it. I'm going to abate that order too, because that's the only way to get to the bottom of it without tying both of you to something that I don't even know yet if Texas has the legal right to do. Does that make sense?
It does, Your Honor. Oh.
Yeah, I think that's the best way to do it. Yeah.
And I think I understand that, Your Honor. So then my question is, I'm wanting confirmation. Does that mean that the default order is currently no longer being enforced at this present moment, and we can return to the 50-50 custody?
You're talking about the default order that is out of Texas.
That y'all made on March 5th of this year.
All right, guys, now the situation escalates from messy to legally complicated. The state steps in and introduces a major twist. There are 3 children involved, but only 2 are covered under any recognized order. That gap alone creates a jurisdictional nightmare. The judge quickly realizes this isn't something that can be decided on the spot and shifts the focus to a bigger issue. Which state even has the authority to rule? When the judge decides to halt everything and call for a cross-state court conference, you can feel the entire case hit a wall.
Yes, it has to be. Because the only order that is in place right now is the Pennsylvania order. That's the one that I know for certain is in place. The Texas order, I don't know if it's a valid order yet, because if the Pennsylvania court retains jurisdiction, the Texas order is void.
That was my understanding as well.
Yeah. So I don't want to do anything, continue moving forward, because if I make a ruling today, it could just further complicate things. So to keep the confusion down, and the best way to do it legally, the cleanest way to do it is to now have that conversation with the Pennsylvania court. And I'm going to try to get that scheduled as soon as possible, because I don't want you all waiting in limbo.
So, Your Honor, sorry, I was a little confused as well. So I know the court's abating these proceedings for the time being, but is the court going to sign an order abating the child support and the conservatorship and visitation and everything regarding all 3 children from Texas, the default order?
Well, the child support order, so they're separate, right? Because I thought the child support was dismissed by the Pennsylvania court.
That's correct, Your Honor. So, but regarding the portions that are still retained by the Pennsylvania court, Your Honor, do you want me to prepare an order that overrules or abates or sets aside those issues? I'm not quite sure what the right terminology would be.
I think right now the best, and thank you for asking that question, because I'm thinking it through a little bit more, because the abating would just put it on hold for now. Right now, I think that needs to be set aside, because we do not know for sure if we have jurisdiction. So I think it needs to be vacated, set aside for the time being, until I can get to the bottom of whatever the Pennsylvania court is going to do.
And that would be setting aside all terms except the child support, or the entire order?
I would think just everything related to the possession and access, because child support is different.
Your Honor, may I say something?
Go ahead.
The child support, though, they use the model for the standard possession order. So that entire child support order is completely unjust and unfair, as it goes off of a standard possession order that y'all didn't have jurisdiction to create. So that child support, if anything was going to be done, which I would personally request that the court vacate in its entirety until we establish a fair establishment of what the custody is, and then create a custody or a child support that establishes based off of the actual facts of this case. What is currently sitting in an order is off of a standard possession order and was done without my presence. So there was no back and forth for me to present that my side of it assesses a massive amount of child support and arrears to me, Your Honor, that pretends as though I didn't have custody of the children and we're moving forward with a standard possession order, and that's what existed. But when in actuality, we have a Pennsylvania order. So if we were going to create child support, it should go off of the 50-50 Pennsylvania, not off of the standard possession. And that's what currently is in that order. So while Texas might have jurisdiction with the child support, what was created on March 5th is not just or fair, Your Honor.
Buckle up, because the father isn't backing down here. He pivots to legal strategy, citing Texas law and arguing that jurisdiction should already belong to Texas since everyone has lived there for years. It's a calculated move, showing he's done some homework and is trying to regain control of the narrative. But the judge pushes back, emphasizing that proper procedure wasn't followed, specifically, the failure to register the prior order. This exchange highlights a key reality in court. Knowing the law isn't enough if you don't follow the correct process.
So, Your Honor, the state would propose then, because we have the child support and the medical support, it's based on a minimum wage presumption, and we would ask the court to maybe make that temporary and to also set aside the retroactive child support judgment for now, and just make the terms of the support, the child support and the medical support temporary at least.
There was retro?
There was a retroactive judgment, Your Honor.
Your Honor, may I?
Your Honor, that entire thing assesses something that is completely unjust and unfair, Your Honor.
Okay, hold on, sir. Hold on 1 second. Let me allow Ms. Cosby to speak. Go ahead.
Thank you. I did ask retroactive support. I have been the only parent to fund the children. Despite 50-50, that does not mean things were being split financially 50-50. I've paid over $2,000 in orthodontic that I asked the father to split, and he told me no. I spent approximately $2,000 on educational expenses. He refused to split. I've been the person to fund pretty much everything, which is why I asked for retroactive support, because I have been the one supporting the children. And our 50-50 agreement was to include splitting major expenses, but that never happened. Also,
Okay.
he said the decisions were made without him present. He was served notice and he chose not to show up for court. Had he shown up, he could have argued these things, but he did not show up for court that day. And that is why decisions were made without him present, because he chose not to show up.
Okay, so this case is all over the place, okay? And I think everybody on here can agree with me with that. And I don't like doing things that are all over the place. So what I am going to do is vacate the entire order. And we're going to start from scratch. I think that's the best way to do it. It manages everyone's expectations. No one is sitting in limbo. You get a fresh start with me. So if the Pennsylvania court says I have jurisdiction, then I will take that up at that time. If the Pennsylvania court says they're going to retain jurisdiction, the Pennsylvania court will do whatever they need to do on their end. But I do not like doing things all over the place. I don't think it works well for anybody, and definitely not me, because it gets harder to enforce orders when things are put in place that are all over the place. And I want both of you to have some finality at some point. All right. So, Attorney Sweet, to answer your question, we're just going to vacate everything. I am going to set up a conference to speak with the Pennsylvania court, and I will report back by order whatever that decision is.
Yes, Your Honor, understood, and I will have that order vacating over to you shortly.
Okay. All right. Well, thank you.
One more question, I'm sorry. Regarding the Pennsylvania order.
Yes, ma'am.
In the past, Michael has told me he will not follow that order. And when I've talked to the police, they have said, take it back to court, and I've showed them the orders, and they just say, well, document it. So what do we do moving forward? Because Gunner doesn't have a legal order, and the order that is there is like every other day custody, and he told me he's going to do the order he feels is more logical. So can we at least state for the record that the Pennsylvania order as it is written is what is going to be bound until we get this done. And both parties are advised to follow the Pennsylvania order if that is what we are expected to hold to.
The only thing the court will advise you all to do is to follow the terms of the court order that is in existence. Whatever those terms say, that's what you have to follow because that's what's
And that is the 2017 order, not 2015, Ms. Cosby.
Okay, so we're not going to go back and forth about what is and what isn't. I'm waiting to see. What I will do is wait to this 2017 order that you file. I will wait until it comes up when I actually get to lay eyes on it. And then I will make sure that I schedule the conference with the judge after that. So I have an opportunity to look at it, give them an opportunity to review everything, and we will go from there.
Understood, Your Honor.
All right. Well, that concludes this hearing. Thank you all for your time.
All right, guys, this final stretch is where everything collapses into uncertainty. The judge explains that abating essentially freezes the case, leaving existing orders in limbo while jurisdiction is sorted out. The father presses hard, especially on child support, arguing it was calculated under assumptions that don't match reality. He claims the system treated him like a non-custodial parent despite years of shared custody. The judge considers vacating parts of the order entirely, which shows just how unstable the situation is. In the end, no resolution, just a legal pause with major consequences still hanging in the air.